Everybody, it's time for us to get started. Woo, now we're live. Welcome to the Senate Judiciary Committee hearing. I'm going to ask Floor Leader Hatchett, if you will, because you did such a great job last time. You'll start us off by opening us up in a word of prayer. Thank you, Senator Hatchett. I have one guest, and actually I guess I'd say four guests I want to recognize when we get started. I have Judge Stephen Knights from Henry County State Court. Judge, you want to stand up? And he started with us back in September, doing a great job in Henry County, keeping things straight in our state court, moving cases along, and brought his boys up here. If you real quickly let your boys introduce themselves to the committee. Ethan? Elliot?
My name is Eli.
Well, I see a theme in all their names, too. Well, good to get to have you all today.
Thank you, Senator,
Yeah.
for the invitation, and thank you all for what you all do.
Yeah, thank you, Judge. We appreciate you. If you feel led, you can always testify today, too. And speaking of that, we have two sign-up sheets up here today, as we always do, for the two bills that we have on the agenda. If you want to be heard on either bill, please come sign up so I can make sure I call upon you. If not, we'll go ahead and collect the sheets. And we will start with the first bill on the agenda, which is Senate Bill 31. Senator Beach, if you want to come up. We are working off of LC 550010. Is that what you have?
Yes, sir.
All right, Senator Beach, the floor is yours.
Well, Mr. Chairman, for 10 years I never came before your committee, and now twice in a week and a half, and it's an honor to be with you, Mr.
Almost
Chairman.
as much as John Albers now.
Well, don't go there.
Okay.
But
Yeah. Very similar.
well, I've got a very good bill for you guys today.
Well, he has a
Anyway.
better streak than you. So far, you're 0 for 1. So.
All right, Mr. Chairman and committee members, thank you for allowing me to present Senate Bill 31. You know, when I was thinking about this bill, we were all elected by the citizens of our district. And, you know, when we come down here to this Capitol, we introduce and vote on legislation that will make the lives of Georgians better. And, you know, I've always said passing a bill is not easy, nor should it be. Mom and apple pie can be difficult to pass down here. And it's hard to get through the legislative process. As I said, bills are introduced, they go through the committee process, there's debate, we refine bills, and then they go to the House and go through the same vigorous process. If it passes, it goes to the governor for his signature, and then it becomes codified in law. This is why I bring before you Senate Bill 31. Our Attorney General is having to step in and prosecute cases that certain DAs refuse to prosecute, laws that we pass they don't want to enforce. In one case, a DA has a list of crimes that she will not prosecute. Now, that's good for criminals to know what crimes they can go out and commit. I just can't believe that's happening. But the purpose of this bill is simple. If the Attorney General has to go and enforce the law in a county that we passed laws, then that DA needs to reimburse the Attorney General for actual cost and expenses. The Attorney General should not have to incur expenses out of their budget for doing the job of a DA that does not want to enforce the laws that we have passed. So, Mr. Chairman, I would just say, and there's an example of this going on right now in the city of Athens. The Attorney General's had to send his unit over there to prosecute some cases, pay for hotel rooms, pay for meals, and it's coming out of his budget. Where I first got this idea was in the appropriations hearings when he was talking about it. I said, well, do you get reimbursed for that? He said, no, it comes out of my budget. And he's asking us for more money, and he should be reimbursed, in my opinion. So, Mr. Chairman, again, thank you for allowing me to present this bill. It's a one-page bill, basically, and I would open it up for questions.
Well, I think you just answered the first question I had is this happening right now? And so you do have examples now of the Attorney General going to Clark County to prosecute
Yes.
cases. And the next question I had, when you look at the way this is written, and maybe this is on purpose, it's a little bit vague as to how much money will be paid by the local government to the Attorney General. And in addition to that, there's no indication if there's some disagreement about the amount that'll be paid. What is your intent with the kind of expenses that would be covered? And have you given any thought into how this will be enforced? You know, because it says the Attorney General is entitled to get reimbursement, but what if there's a disagreement between the local government or the District Attorney's Office and the Attorney General?
My intent, and if we have to tighten this up a little bit, is for them to be paid for the attorney's billable hours, the meals, and any lodging expenses. Nothing else. I don't want them to bring in very expensive expert witnesses and have to charge the county. That's not the intent. It's just for the billable hours of that attorney being out of the Attorney General's office and doing that DA's job, and the expenses of hotel and meals.
All right. You do have some questions in the committee. Senator Kennedy.
Thank you, Mr. Chairman. Thank you, Chairman Beach, for bringing this. So, question beginning with line 12. I just want to make sure I understand what your intent is. This says when a district attorney fails to prosecute a criminal case or cases that the DA and the Attorney General have concurrent authority to prosecute, and then it goes on. So, is it your intent that this bill only apply to the failure of the district attorney to prosecute or participate in prosecutions where it is the type of matter that the DA and the AG have concurrent jurisdiction on?
Correct. I will give you an example. When we passed the heartbeat bill, we had a DA in the metropolitan area go on Channel 2 News and say she was not going to enforce the heartbeat bill, period. That's not her. She doesn't have the authority to do that. We passed the law. The governor signed it. It's in our statute. She should enforce our laws.
And
if the DA has to go do that, the Attorney General, then he should be reimbursed for her not willing to do her job and her responsibilities.
And I understand that, and I'm very sympathetic to what you're trying to do. So, but I think the way this is written, and I would ask if either Ledge Counsel or the chairman reads it the same way, that what you're describing would only apply to the district attorney's failure to prosecute cases where there was concurrent authority. And my understanding is that authority doesn't exist for the prosecution of all crimes. And you're describing things,
Okay.
very appropriately, I think, but I don't know that some of the things that you're describing are matters over which a district attorney and the Attorney General have concurrent authority. And I'm just telling you, I think the way this is written, it's limited to that.
Okay.
And I don't know if that's what you're trying to do. If it is, fine. Maybe that clears it up. But your description is, your explanation to me is not quite matching up with the wording.
Okay.
I think it'd be good to get from Ledge Counsel, if we do this on the fly, I don't know, or Senate Research, what crimes does the Attorney General have concurrent jurisdiction over a prosecutor? Do we know the answer?
Yes, they do.
What's your mic number?
Number 2.
Number 2.
So in the summary that should be in your folders, there's a section that details this. There's concurrent jurisdiction for prosecution of violations relating to deceptive commercial emails, relating to domestic terrorism, regarding trafficking a person for labor or sexual servitude, and under the Criminal Street Gang and Terrorism Prevention Act.
In a nice way, what she's saying, if you'd read what I already wrote for you, you'll see it sitting in front of you in your folder. And so she listed out 4 items. I blame the pro tem, unless you're just throwing a softball to me, and I missed it. 4 items here that are referenced in the summary where there is concurrent jurisdiction. Have you seen the summary?
Yes, I saw it.
Okay. All right. We have other questions. Do you have anything else, Mr. Pro Tem?
No, sir. I think as long as the author's intent is for this bill to apply to those 4 categories, then I think what you're describing matches up with the way the bill is written.
Okay. Yes, sir.
Senator Parent.
Thank you. Thank you, Mr. Chairman. Thank you so much, Chairman Beach. Just a couple questions. First, you referenced a situation in Athens where folks have had to go in. So can you tell me under what legal authority the Attorney General's folks went in, and also what the crimes were, and elaborate more on that specific situation?
All I know is that when he was in our appropriations meeting, I think you were in there, when he presented, he said he was having to send people to Athens, Clark County to prosecute cases that DA wouldn't prosecute. And I asked the question, are you being reimbursed? And he said no. And that's where I came up with this idea. I said he should be reimbursed.
So I guess my question is, if it is under concurrent jurisdiction, then that would make sense to come out of the AG's budget.
Well, I don't know what's going on over in Athens. I'm not sure. Do we have any? Senator Calvert's not here, but I do know they're sending resources over there to prosecute cases.
So I would love to know, and I can reach out to their office, of course, too. I mean, or you and I can chat more offline, just given that it's the genesis of the bill. It would be great to hear more about exactly what the situation is over there. And then, the other question I had is, in any, district attorney's office, there are going to be limited resources and decisions that have to be made about what can be prosecuted and sort of what are the priorities. Do you think there's a role for that sort of decision making? And if not, how do you envision it to be workable to run a district attorney's office without allowing for some of that give and take of prosecutorial discretion, understanding limited resources and priorities for the safety of particular communities and what they desire?
I would tell you, I think DAs should do their job and prosecute cases if it's brought before them. If a crime was committed, they should do their job.
But what if, I guess my question is, there's going to be instances where it literally is impossible to prosecute everything that is brought before you. And that's where prosecutorial discretion comes in, because tough decisions have to be made, and it's usually done in conjunction with the needs of that community, the desires of that community, because they're obviously responsible to their voters. So I guess I'm presenting an instance where I just don't, I believe what you're saying, I don't think always is realistic. And so I'm just curious your thoughts.
Well, I don't think the Attorney General would step in if it wasn't needed, if he didn't think that it was a crime that needed to be prosecuted.
Thank you.
Question from Senator Hodges.
Thank you, Mr. Chairman. Chairman Beach, if under your bill, what would happen in the unlikely, or maybe likely, I'm not sure, event that the Attorney General and the DA, for whatever reason, agreed that the Attorney General should prosecute a particular case rather than the DA? Would there be some leeway so that
he would not have to bill them if he agreed to do that.
Okay.
This would just be if they were not doing their job. There's a case right now in DeKalb County where the DA has said, I think it's better if you prosecute it, and the Attorney General has agreed. So I don't see that. Same, I think, happened in the Aubrey case down in Savannah. The DA the Attorney General was asked to come in and agreed to come in and prosecute the case. So that was a mutual decision.
Thank you.
Senator Jones.
Thank you, Mr. Chair. Just a question. What if there was a disagreement between the two, the DA and the Attorney General's office, but the district attorney was like, we don't think this is a good case. We know the witnesses better than you do. They're not going to come across as well as you think they are. You're going to lose. Attorney General brings it anyway, brings the case, spends $30,000, $40,000. They were told the case was not going to go. It's not going to work. They still went ahead and forward with it. Should that come out in the district attorney's office?
With this bill, yes, it would.
Would that be prudent? Why would that be? The district attorney knew that how this case was going to go because he's the local person. I'm just asking.
If the Attorney General wanted to go in there and prosecute it and thought it was a case that was a bad crime that was committed, he should have that right to do that. He's our state #1 law officer.
All right.
Senator Setzler.
Thank you, Mr. Chairman. A friendly question for you that trying to maybe help you accomplish what you're trying to accomplish. I'm concerned the term fails to prosecute. I'm concerned that if you have a circumstance where the prosecutor's office sort of knows this potential's out there and says, oh, yeah, we got this covered, and they're working some misdemeanor plea deal, plea down something very serious down to something kind of trivial, that they could be, quote, prosecuting the case while they're really not prosecuting the case. I think you're trying to create a circumstance where the Attorney General can advocate for victims, bring the heat where heat needs to be brought. And I'm concerned that if you limit it to those cases in which it fails to prosecute, if they have an open case, they've got a person assigned to it, an assistant DA assigned to it, and they're working it, or they've got a plea deal planned, and the Attorney General wants to get engaged, they could say they're not failing to prosecute the case. This wouldn't apply. It would seem to me that what you're trying to accomplish is any circumstance in which the AG comes in and prosecutes, you get it, you get the dollars, unless they were requested by the county, in which case they wouldn't. I mean, it seems to be more of because if you're limited to the circumstances enumerated in these where you have concurrent jurisdiction, this could limit the number of cases, or this could limit the circumstances in which the AG could come in anyway. So this part of statute is a limiting effect on the kind of things that you're prosecuting. So if you simply were to say, essentially, whenever you come in and prosecute a case, you have access to dollars unless you're requested by the locals, you're not creating a circumstance where if the locals were kind of slow rolling this and sort of treating the crime with kid gloves, you're kind of precluded from coming in and getting engaged, which is another issue of how concurrent jurisdiction works. I know there's some particulars there, but I think your limiting language is going to throttle down the circumstances in which the AG may be able to get involved in ways maybe that you don't want to. So, just trying to help you.
Okay.
One thought I have, which maybe it's no good, but I'll say it anyway out loud. Would it be better to have a process where the Attorney General, after they do step in a county, on a circuit, they could petition the Superior Court, whether it be in that circuit or in Fulton County, wherever the right venue would be, based on some certain standard, they should get reimbursed costs because basically the prosecutor is playing politics, as you're trying to accomplish. Would it be better to have a system like that where a court would fix this versus us having something general without knowing exactly logistically how it would work? If you have any thoughts on that, just throwing it out there.
I'm open to that. All I'm trying to accomplish here is, in his comments, when I've spoke to him, he really wants to crack down on street gangs and gangs. And there are some DAs that are not putting pressure on these gang members, and there's a revolving door, and he wants to get tough on these crimes. And if they're not going to prosecute them, he is. And I just feel that if he's going to have to go do that work, he should be at least reimbursed billable hours and expenses.
And then if you had a system set up where there was a hearing on it, and the example given by Senator Jones, then that would not be something that would apply. You wouldn't have to worry about that situation. You're talking about situations where truly a prosecutor may not be doing their job and are forcing the state to come in. I think that creates a good argument that the state should be reimbursed. It's just a thought. Maybe other people have better thoughts. Senator Calzert.
Thank you, Mr. Chairman. This one hits home to me. I'm seeing the same problem you're trying to address here, and I applaud you for this. It occurred to me as the minority whip was questioning you about, what if it was a fruitless prosecution and the DA was using good, sound judicial discretion not to waste their resources prosecuting it? Should they still be stuck doing it? You might be receptive to a proposed amendment here at line 14 after criminal case or cases and say, and obtains a guilty plea or conviction. I think, Senator Jones, that might address your concern that if the Attorney General's office comes in and prosecutes where the local DA wouldn't prosecute, and they're successful, so they prove their case either through a plea or a jury conviction, then they get the reimbursement. Would that be satisfactory to you?
I'm
that
good with
that protects that judicial discretion, the prosecutorial discretion, I guess is the phrase, and that if they were right, they're not going to have to pay, and it's eventually the Attorney General will quit prosecuting weak cases themselves if they're not getting reimbursed. just a thought. I also like the chairman's idea about having some judicial review of it, so it's not automatic, but I'm good either way.
I would accept that amendment if you want to make that.
And also I guess as a follow-up to what I said, if there's a disagreement, I guess that's where it would go anyway, because it doesn't say how a disagreement will be resolved. So I don't know if this would be interpreted to require some sort of suit over it regardless. I don't know. Senator Rett?
Thank you, Mr. Chairman. I just had a thought. I was just looking at it, that this can possibly put the two entities at odds because of a possible overreach due to political pressure, where the local people, just like my two colleagues here were saying, have a better sense of the situation. So you always have that potential of possible overreach due to political pressure. But that's just me thinking. Once in a while I do that.
Any other questions from the committee at this time for the author? We do have another one. Senator Sessler.
To the author, and I know, is the chair going to entertain amendments, or do we want? What's the chair's posture as far as accomplishing what the gentleman mentioned about the guilty plea?
Well, I think amendments will be welcomed on a bill like this, and so it sounds like something that would help the bill and go further to his intent as well. Do you have something else you want to suggest?
I was just asking about the language, with the Attorney General prosecutes any case, any criminal case or cases, he mentioned obtains the plea of guilty or conviction, and then could you accomplish the chair's suggestion by adding in the clause, upon approval of the Superior Court, comma, the department shall be entitled to reimbursement? I mean, the process of petition and all that stuff could be worked out in the court rules, but if you put in, the amendment I was going to propose was, and this is just open to the committee, was literally, because I don't know that fails to prosecute, and then the reference to the concurrent authority, I don't know that either of those are helpful to this. If the only cases they can prosecute are those that are already given to them for concurrent jurisdiction, that's settled over here in this, in the AG's other code section. So it would seem, if you have the word starting on line 14, if you simply said, when the Attorney General prosecutes any criminal case or cases and obtains a guilty plea or conviction, comma, upon the approval of the Superior Court, comma, the Department of Law shall be entitled to, you accomplish what the chair said, you accomplish what Senator Calzert said, and it's just, you get rid of those other limiting effects that I think could create chaos. I don't know, but
Counsel Paul, could you suggest some language that would accomplish that? I know we want to say which Superior Court, and I'm assuming it'd be the case, the Superior Court that had jurisdiction and the venue was proper for the trying of that case would probably be the intent, versus setting a Superior Court in advance, because they'd have knowledge potentially of the case too. Do you have some language you could suggest for both potential amendments? Which mic are you? I'm going to turn you on.
I could draft something up. I think it would be better done if I get back to the office and work on it. But certainly, and so first of all, what I'm hearing is a request, I think, to delete lines 12 and 13, and then line 14, delete failure, and start that sentence with, when the Attorney General prosecutes such criminal case or cases and obtains a guilty plea or conviction, the Department of Law shall be entitled for reimbursement of actual costs and expenses, and going on through line 17. And then, Chairman, what I'd want to do is probably make that a subsection A, and then create a subsection B that implements a process whereby the Attorney General would petition the court in which the prosecution occurred for these costs. There would be a hearing where both sides could present their evidence, and then the court would make a decision.
Okay.
I think that's best to clean it up and do it that way. I know there's some more questions in the committee. As the author, would you rather us work on that as a substitute to bring back?
I'd like to do a committee sub and work with you and get this right. I want to do it
Best
right.
laws are written on the fly like this.
Yeah.
So.
Okay.
We have a couple other questions. I say one other question from the committee. Senator Hatchett.
Thank you, Mr. Chairman. And I guess this just goes to the intent of the author here. It says that the funds that would be used to pay the AG are from those funds made available to the district attorney's office that they'll prosecute such criminal cases.
It's on, but it's not. You want to use the lameness, yeah.
Those funds, obviously, and I may be mistaken, but I'm at least in my neck of the woods, DAs are funded by counties and from the state. Would you want to tap into the county funds as well, or just limit it to those funds that are drawn down from the state?
I would want to tap into the county funds, and I think if the DA, the commissioners fund the DA's office. So then I think if they had a DA that was not doing their job, they would probably look at that DA's budget. So it would really, I think, help the DA to do its job if they thought they were going to be in danger of losing future funding.
Are any other questions from the committee for Chairman Beach? All right, we have one person signed up to speak on the bill. Speaking of the counties, Gabriel Carter from ACCG. Mr. Carter, if you want to come down. Good afternoon.
Good afternoon. Thank you, Chairman Strickland. Thank you all, fellow committee members, for allowing me the opportunity to speak. I'll just start by saying my name is Gabriel Carter with ACCG, representing all 159 counties. You all brought up some of the same kind of questions and concerns and thoughts that we have. I guess I'll first start by providing some brief context. As the senator mentioned, district attorneys are a unique office in that they are funded both by the state and the county. So the state usually covers things such as travel expenses, and the county usually funds things such as witnesses, expert witnesses. So we have two concerns primarily with this bill. We aren't officially opposed to it, but just want to bring up some conversation. The first is that district attorneys are elected positions. Counties don't have any kind of discretion or authority to tell district attorneys, to prosecute cases or not to prosecute cases. So I think what we want to make sure is that if there's going to be a penalty that's aimed at district attorneys, that goes towards them and not the local taxpayers, because they will be footing the bill for this reimbursement. Secondly, with the AG's office stepping in, one of the concerns we have is that if they bring in an expert witness from California that costs $200,000, $300,000, there's no kind of local accountability to make sure that, whereas a DA would have more local accountability to make sure that they're taking care of the funds because they have to report, directly to their elected district. So we just kind of want to bring up those concerns with you all, and we'll be, open to a process where maybe a Superior Court judge is able to intervene and make sure that these funds, if there is a disagreement between the counties or the DA and the Attorney General, a Superior Court judge is able to kind of arbitrate that process a little bit, or clarify that state funds are being used for this reimbursement. So I think the DAs already have state funds set aside for travel expenses. So if they get that reimbursement from state funds, that'll also be something we are open to. So wait for any questions.
All right, thank you, Mr. Carter. Any questions from the committee? Senator Rett.
Thank you, Mr. Chairman. So you're saying that in some of these smaller jurisdictions, I'm sorry, I'm tired. Been a long day. Jurisdictions, the cost of bringing somebody out, let's say, like you said, from California, paying $200,000, maybe their whole budget for the year if they have to reimburse.
That would definitely be devastating to the local taxpayers in that county.
Any other questions from the committee? All right, thank you, Mr. Carter.
Yeah, and I'll just say I look forward to working with the author to see if we can find a good solution for this.
All right, thank you. Senator Beach, I think what we'll do is let you get with Legislative Council and work on that language and share it with Mr. Carter, if you will, because I think the Superior Court judge part there would alleviate a lot of his concern that he's raised. It may not alleviate, you may have a disagreement about where the funds are going to come from, and that's fine, but I think most of his concern about this being evaluated by somebody that could determine if there's some issue with the availability of funds, like that example that was given, that would be solved by having a Superior Court overlook this. You'd also have that local judge looking at it. So if you're going to break a county, that local judge would be making sure that's not going to happen on this as well. So you have any final thoughts for the committee?
Just thank you for the input and the help with this, and you knew what my intent was.
Yep.
Thank you very much.
All right. Thank you. All right, with that, we'll move on. We'll hold on taking any action on Senate Bill 31 and move on to the next bill on the agenda, Senate Bill 59. Senator Hatchett, you want to go down there? Yeah. All right.
Former Inspector General testified with me, if that's all right.
Okay. It's time. And we are, I'll let you get seated and catch your breath. We're working off of LC 442202 EC. Is that correct?
02 EC. Yes, Mr. Chairman, that is correct.
All right, and Senator Hatchett, you have a guest helping you today as well, if you want to introduce him too.
I do. This is former Inspector General Scott McAfee, who's going to help answer any questions the committee might have that I'm unable to answer, or if he can answer it better, he may just go ahead and answer them.
All right, thank you, Mr. McAfee, for joining us as well. All right, the floor is yours.
Well, thank you very much, Mr. Chairman. Today I bring you Senate Bill 59. This is being brought on behalf of Governor Kemp. This bill would finally codify and grant law enforcement authority to the Georgia Office of the Inspector General. This bill is about transparency and accountability. At its simplest, the Inspector General's office exists so that the public can trust and have confidence in our state government. It's not about expanding government. It's about taking what we already have and making it better. The Inspector General's office is an independent and objective watchdog tasked with oversight and investigations of fraud, waste, corruption, administrative violations, ethical lapses, and sexual harassment throughout the entire executive branch. Just a brief history about the IG's office. Civilian IGs have been ingrained in our federal government for over 40 years and have grown to include approximately 75 different IG offices with a combined budget of over $2 billion. At the state level, Georgia's IG office was created by an executive order from then Governor Sonny Perdue in 2003. 10 other states now have statewide IG offices, and each one has statutory authority and some form of subpoena and law enforcement power. After 20 years, we think it's time for Georgia to join these states and make Georgia's OIG a truly effective crime-fighting and fraud-preventing organization. They have done great work despite their limited authority, and we think they can do a lot more, and this bill will allow them to. This bill is based on model language compiled by the Association of Inspectors General, our current executive order, and on legislation passed by other states. But most importantly, this bill designates the office as a law enforcement agency and grants the office the authority to obtain subpoenas and search warrants. Their lack of designation as a law enforcement agency has impeded their criminal investigation and effectiveness in a number of ways. We believe that this will help them, will make their job easier, and will do better for the people of the state of Georgia. And Mr. Chairman, with that, I will I'll open for any questions.
All right. Do we have any questions from the committee for the author? Senator Cowser.
Thank you, Mr. Chairman. So what's the authority for the Inspector General currently absent this bill?
If you want to answer that.
Senator, the current authority for the Office of the Inspector General comes from an executive order issued by Governor Sonny Perdue that has remained in effect since 2003.
Any other questions from the committee? All right, we have one person signed up to speak on the bill. If y'all want to sit right behind there. Mr. Thomas Weaver. Welcome back, Mr. Weaver.
Thank you, Mr. Chairman.
The floor is yours.
Mr. Chairman, members of the committee, I rise in full support and approbation of what your colleague is trying to accomplish. Senator Hatchett's bill for really clarifying what the Office of the Inspector General can do ever since its establishment through executive order back in 2003 is great. And I'm a big believer in transparency in government, and this will be a huge augment and supplement that effort exponentially. I have a couple of small concerns, and I don't want to resort to using the word begging, but I want to ask the committee to seriously consider something here, and it would be my hope that the committee will find it favorable. Let me start by saying that I have an abundance of respect for our elected Attorney General, Chris Carr, and I'm not trying to elevate the Office of the Inspector General as an appointed agency or as an appointed agent above an elected office. So I don't want to give the impression that I'm stepping on anyone's toes. I don't want to give the impression that I'm trying to do anything that's not good. But under this, if you'll look on line 65, this legislative measure would give this office a statutory authority to investigate certain crimes, but it only cabins it to those two articles of that chapter of the Georgia Code. And when you look at that chapter and those two articles, it mostly governs either a violation of an oath of office or accepting more than one office in employment based on separation of powers issues. The big ask that I was going to ask this committee to consider, and I was going to be on the record asking this publicly, is whether or not this committee, and I had a conversation with with Senator Hatchett beforehand and also others, and you might have got the email that I sent for each of you too. My emails and what I asked in that might be a little too broad, and quite frankly, it might be just stepping on some toes. But to the extent that you're willing to consider giving this office the power to employ peace officers to investigate crimes, my big ask of all of you is on line 65, if you would be willing to delete the words of Articles 1 and 2 of Chapter 10 and just leave it blank at Title 16 and allow them to investigate any crime under the title. Because the title itself is large, it's voluminous. It encompasses 3 volumes of the Official Code of Georgia annotated, 14A and B. And that's a lot of territory there. That covers everything from, you name it. It's all in there, right? But if you're going to consider seriously giving this office the authority to employ peace officers whose duty it is to investigate crimes, I don't speak for the author or for the office. I was just going to ask publicly whether or not those peace officers should have the power to investigate any crime as opposed to just the few that you name here. And I don't know how they feel about that. And again, I want to be careful. I'm not trying to step on the Attorney General's toes. But that was the big ask that I was going to ask this committee. And speaking with them, the language that I was thinking about and the email that I sent you was far broader than that, so I'm going to take that back. I apologize. It was a good thought for the time, but I didn't consider the Attorney General angle when I sent it. But after giving that some thought and allowing that to stew overnight, whether or not the committee would be amenable and whether or not it's acceptable to seriously consider allowing those peace officers to look at any crime as opposed to just a few. And the other concern, talking about those peace officers, it wouldn't be me being me if I didn't come up here and say something about firearms, now would it? If you would look on line 174 of the bill, those peace officers would be able to have the power to carry a gun, notwithstanding Code Section 1611, 126, and 129. But there's a few code sections in between 127 and subparts 1 and 2. I would ask whether or not the committee would be willing to consider delete the word and insert the word through, so that those peace officers would have the same ability to carry a firearm the way any other peace officer would, as opposed to just those 2 code sections, which really doesn't give them much because I can do those too. So they really wouldn't be much of a peace officer if they only had the power to carry that gun the same place that most citizens already can, as opposed to what other peace officers can go above and beyond it. Again, I just wanted to point that out. But saying that to say this, this bill does enable, if it should reach gubernatorial assent and ratification in its current form, it does give the Office of Inspector General the power to employ those peace officers. And seeing as how they're peace officers and peace officers enforce criminal law, I was just, again, not to be redundant, but for last strike, I was just wanting to hope, perhaps not beg, but hope that the committee would find it appropriate to consider that and to debate that perhaps with the author and the author's presenters. Thank you, Mr. Chairman.
All right, thank you, Mr. Weaver. We always appreciate your feedback. Any questions from the committee for him before he goes?
Sorry about that.
Oh, you're good. All right, no questions at this time. Thank you. Do you want to come back up, and do you have any response to because what Mr. Weaver was mentioning, obviously being an expansion of the powers in your bill. I don't know how much your bill mirrors what the current executive order is. You mentioned it's more of a model legislation looking at other states. Do you have any response to what he said?
Well, first off, Mr. Weaver's always bringing very good thoughts and stimulating conversations to this committee. As far as the expanding the scope of this bill, right now the fiscal impact of what we're trying to do would be $250,000 for the state. Expanding their jurisdiction and scope may increase that. Right now, the Office of the Inspector General has 10 employees. If we expand it too much, I don't know what the fiscal impact would be, which is why I would respectfully ask this committee to pause on any amendments there. Maybe we can get this bill passed out, and potentially, after consulting with the AG, the governor's office, and the other powers that be, about the scope and about the fiscal impact, maybe make a change in the House or before it goes to the floor. But for now, as far as that goes, I'd want to keep the language the same.
Sounds like a fair approach to me, given the work y'all did on the bill leading up to the day as well, in coordination, of course, with the governor's office on this. Question from Senator Setzler.
Thank you. I wanted to ask about Mr. Weaver's question about lines 174, the 1611 126 and 1611 129. Could that have been a miss? Is there a, I don't know those code sections by heart to know if there's things in 128, 7 and 8 that were intended but were just not caught the right way. I don't know how those things operate, or if this was calculated for a specific reason, they would have different, gun carry privileges than a normal peace officer. That would be an easy miss to make if that were not.
I am not familiar with the exact verbiage of 126 through 129. In just reading this, it says notwithstanding code sections 1611 126 and 1611 129. And pardon me because I don't have it in front of me, but I feel like it would make it more limiting if we include more, because it says notwithstanding. So I would have to look at those code sections specifically before I could make a suggestion on that.
Are any other questions from the committee for the author? All right, I think the thing to do is, if the committee is willing to move forward on the bill, and you could look into that some more as the bill moves forward, and also look into the other question asked by Mr. Weaver as well, if you decide to as the bill moves forward. So what's the pleasure of the committee? I have a motion to pass by Senator Setzler and a second by Senator Cowser. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. All right, on to rules.
Thank you very much.
All right, thank you. And with that, we are adjourned. Thank you all very much.